The first thing to understand is that legal issues with AI vary based on a number of factors. And at a minimum, they factor based on the company's role with AI, the tools they use, how they use them, among other things. On the liability side, who's liable if the output of generative AI tool infringes? Is it the tool provider or is it the user? Short answer, it could be either or both. The use of biometric information is something the FTC is very focused on, but it's important to understand that biometric information could include not just facial recognition, but fingerprints, iris scans, voice prints.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, James Gatto. James Gatto is a partner in the Washington, D.C. office of Shepard Mullen. He is the founder and co-leader of the 110-plus artificial intelligence team and co-leader of the blockchain and fintech team. He has over 20 years of experience advising clients on AI legal issues and is an adjunct professor at Ole Miss Law School teaching AI legal issues. He's a prolific blogger and writer and has been invited to speak internationally by governments, industry organizations, and companies on AI legal policy issues. He helps companies understand AI legal issues and develop policies to manage the risks, handles AI agreements and transactions, and advises on all aspects of legal and regulatory issues with the development and deployment of AI and open source issues with AI code generators. The webinar that you're about to watch will be approximately 1 hour, and once that's complete, James will be taking audience questions. So please feel free throughout the presentation, if you have any questions, to submit them through that Q&A button in the control panel at the bottom of your screen. Now, without further ado, here's James to discuss advising on AI, guiding your clients through AI challenges.
Welcome, everybody. Pleasure to be here today and to talk to you about some of the thorny issues with AI and really how to navigate them and manage the risk as you and clients use your AI tools. So without further ado, let me jump into this. Nina did my background, so skip over that. Just a brief overview of what we're going to cover today. Primarily AI legal issues, some policy issues, and then really a lot on risk management. There's many pending lawsuits where there's unresolved legal issues relating to AI, the number of regulatory enforcements. We'll talk about some of those. We'll talk about the current U.S. AI policy, primarily as set forth in the White House executive order on AI, and some of the recently passed and pending legislation relating to AI. And then we'll talk about how to manage the legal risks. Okay. So the first thing to understand is that legal issues with AI vary based on a number of factors. And at a minimum, they factor based on the company's role with AI, the tools they use, how they use them, among other things. So what do I mean by the role that a company plays with AI? Within the AI ecosystem, there's many different players that provide different aspects of what goes into making AI. Then there's companies that use AI. So for example, in order to have an AI application, you have to do what's called training an AI model. This requires a lot of data. There's some companies that are just harvesting and mining data and licensing it to other companies. There's other companies that are sitting on a lot of data just based on their existing business model, and they're using that to license data. We've seen some big media companies licensed to some of the big AI companies. Those are examples of data providers. Then there's the companies that are training AI models. And then there's companies that are developing tools that use the AI models. And in some cases, companies play more than one of these roles. So a company may collect their own data, train the AI, and develop tools. In some cases, that may be fragmented. Then you have companies that are deploying or using AI tools. And then you have companies that are modifying or enhancing third-party models that have been trained through processes called fine-tuning or RAGs, which is retrieval augmented generation. And lastly, in some cases, companies just use content that's generated by third parties. So just like companies hire third parties to develop software or create imagery for marketing, et cetera, sometimes companies will just rely on third parties who are using some of these tools to create the content. So these are some of the types of roles. There's others, but depending on what the company does, their legal issues and their risk profile may vary. We'll talk about that as we get into it. As far as tools, there's many different AI tools, new ones popping up every day, but at a high level, one of the things that's really kind of been prevalent is content generators through what's referred to as generative AI tools. So these are tools that can create pictures, movies, songs, text, all types of creative content. We see a lot of chatbots that are used to interface with customers or consumers that try to provide relevant information to consumers in a natural language type way without having humans in the loop in many cases. There's AI code generators. Almost all developers now are already adopting these AI code generators. These are AI tools that assist developers in writing code. They literally will auto-complete lines of code. In some cases, it'll check the syntax and check for errors in code. And in some cases, developers can just ask the tool to provide a chunk of code. For example, and they say, I need a calculator function in this application, and it'll create code that would create a calculator function. Then there's other tools that are of significant regulatory concern, and these are typically deemed to be what's called high-risk decision tools. In many cases, and we'll cover this a little bit more, these are typically things that have an impactful, that these are tools that create or assist in rendering decisions that can have an impact on consumers, patients, uh, uh, in lending situations, your borrowers, students, as far as decisions getting into school, anything that can impact a person. Many of these tools are deemed to be high risk decision tools. And those are some of the ones that have been more thoroughly regulated, and we'll talk about those a little bit more in detail. And then the uses, the way companies are using the content vary as well. You can see here various examples, and I won't go through them. You're probably familiar with many of these, but depending on the types of content that a company is generating and what they do with it may have an impact on what the legal issues are. So the only reason I go through this is to say there's not like a one size fits all that applies to all companies here. You really need to understand, if you're advising a company, what are they doing with AI and how are they using it and what tools are they using? Okay. I'm going to go through at a high level some of the key legal issues. I'm going to drill down on some of those in more detail. You'll see here on most of these, I've got a link to either articles or blog posts or some other content that goes deeper into these topics. But one of the things we needed to understand is what's called algorithmic disgorgement. This is a penalty that can arise from improperly training AI on data that you don't have a right to use for training AI. I'm going to give you an example of that in a second. But the impact of this, and one of the reasons I put this first, is that it's very expensive to train AI. The result of algorithmic disgorgement, if a company is faced with that, is they have to delete the AI model and anything derived from it. And so it kind of wipes out an entire investment. So obviously that's one of the things you want to avoid. On the copyright and IP side, it's important to understand the Copyright Office has issued guidance and decisions, and there's been some court cases that have upheld this, that the output of generative AI is typically not protectable by copyright because it's not human authored. We'll touch on that a little bit more detail as well. So it's important to understand that if a company wants to create content or have content created for it by a third party, for example, that they want copyright protection for, using generative AI is maybe a problem. One of the things we're seeing pervasively throughout every company is that employees are using AI. And in many cases, if companies haven't adopted a policy on AI use, employees are just using the tools they want to use without understanding the legal risks that come along with it. We'll cover some of these in more detail, but some of the things where there's been actual issues already is companies will use a public generative AI tool and put in confidential information. There was an example of an employee who had put in confidential information about a new business plan that a company was adopting and asked the tool to draft a business plan based on the information that was put in. And the information put in was confidential. It later got output to another company, and that the confidentiality was lost. There's a lot of issues in understanding that the inputs to and outputs from AI that a company provides. In some cases, you're actually licensing that back to the tool provider so they can use your inputs to retrain the AI models to make them better. There's risks with that. Indemnity is a big issue. There's a lot of potential issues with these tools. There's can be infringing output, other types of things. It's important to understand that with some of these tools, you are actually indemnifying the tool provider. They're not indemnifying you. And so some of the tools that have those types of terms, many companies won't approve, but employees, if there's no policy, are using it, not understanding that that's what the legal situation is. Those are just a few examples. We'll cover some more later. And I mentioned earlier, AI code generators are very powerful tools that their developers are getting a significant increase in productivity using these tools, but they're trained on open source software typically. And for those of you who are familiar with open source, most companies have an open source policy for managing open source. Using AI code generators raises new issues, and we'll cover that as well. There's a lot that goes into training AI models and building AI tools. And you may hear the term responsible AI development. That simple word has a lot of complexity behind it. There is a lot of things that need to go into ensuring a AI tool is responsibly developed. It needs to be, you need to ensure that it's tested so that you minimize the inaccuracy in the outputs. You need to ensure that it's trained on sufficiently representative data, that the outputs don't create biased or discriminatory results. And there's many other issues as well. We'll touch on some of those. One of the things that's important, as we'll see in managing risks, is to develop policies, as I alluded to. And part of the policies typically involve deciding on a company-by-company basis which tools the company will permit their employees to use and which versions of those tools. As we'll see, the same tool may have different versions and the legal terms may differ. We'll talk about some examples there. But for these and other reasons, it's important when companies are deciding whether to use a tool, just like you do vendor diligence for any technology you adopt. You need to do all of that with AI, but there's additional issues that are unique to AI that require enhanced vendor diligence. And we'll talk about that as well. There's a number of state laws that have passed. There's not that many new laws actually that are passed on that are AI specific. But the number of laws will be increasing. There's a lot that are pending. California, Utah, Colorado have passed laws. Some of the laws have simple disclosure requirements. For example, under Utah, if you're using an AI chatbot to interact with a consumer, you need to disclose that up front so the consumer knows they're not talking to a real person. Colorado law has pretty comprehensive consumer protection with respect to AI, and it doesn't come into effect until February 2026, but it imposes obligations on both developers and deployers, meaning users of AI tools. And then internationally, I'm not going to go into it very much, but probably one of the most significant pieces of legislation that's passed is the EU AI Act. And it's important to understand that while it's the EU AI Act, it may have extraterritorial effects. So even if you are building AI here, if it's going to be used or deployed, for example, in Europe or in other circumstances, the EU AI Act may apply to you as well. So these are just some of the issues. We're going to go into more detail. Let's focus on the IP side first. As I mentioned, Copyright Office has issued guidance. There's a link there to it. And as I said earlier, basically, the output of generative AI is typically not protectable. Under the copyright law, only human-authored material can be protected. So if something is output from generative AI, is not protectable. Now, some people say, well, if a human provides the prompt and the idea for the output, is that sufficient? And the answer is no, because ideas are not protectable under copyright. The actual creation of the content is being done by the AI tool, according to the Copyright Office, so you can't protect it. doesn't mean there's no copyright available. Generative AI may be part of a work that's human authored, and you can get protection for the work as long as there's human authorship. You have to disclaim protection for any portion that is AI generated. Same on the patent side. So you can patent AI technologies like any other technology. The law is the same. There's no different rule. In fact, roughly 20% of all the patent filings this last year or so are AI related. A very significant percentage of patents that are being filed are somehow related to AI, and they're being issued. You can use AI. The Patent Office just issued guidance. You can use AI to assist in generating inventions, but there's a test that goes along with this. And the test really focuses on, is there significant human contribution to the invention? Won't get into a debate about whether AI can invent things or not. Short answer is it can. A lot of people don't believe that, but there's been patent applications filed where AI has been listed as an inventor, and the patent office will not grant those patents because you can't list a non-human as an inventor. So if something is purely AI invented, it's not going to be patentable. Those are some of the highlights there. Inputs and outputs. So the inputs, if any of you have used, I'm sure most of you use generative AI, whatever you type into the AI as a prompt or an input, it's important, as I mentioned, to make sure that you understand what that tool is doing with those prompts. In some cases, in the more desirable cases, it takes your prompt, it processes it, it generates the output you're looking for, and it deletes the input prompt, and it doesn't retain it, and it doesn't use it for other purposes. But in other cases, some of these tools will actually retain the prompts and the outputs and use it to retrain the tools to make them better over time. So how do you know whether it's doing that or not? There's a couple of levels. One is typically companies will disclose in their marketing or product description what they're doing. Second, you'll typically, even if you don't see it there, it'll typically be in the terms of service, because most of the companies that are using the content will, in the terms of service, say you are granting a license to the tool provider to use your inputs and outputs. So you're granting an express license by accepting the terms. And this is an important thing when it comes to employees that are using tools without understanding this. In many cases, there are free versions and there's enterprise versions of the same tool. And the free version often will have a license back to the tool provider, whereas the enterprise version won't. So this is one simple example of a criteria that, as a company, if you're going to adopt a tool, you're typically going to want to use the enterprise version and ensure that your inputs and outputs are not reused. Okay, on the liability side, who's liable if the output of generative AI tool infringes? Is it the tool provider or is it the user? Short answer, it could be either or both. If the tool provider is using copyrighted content, for example, to generate content, they may be creating an unauthorized derivative work, or they may be substantially copying the material that the AI was trained on and producing an output. As a user, if you get an output and you publish it or you make copies of it, if it's infringing, you may be liable as well. So there's potential liability to both parties. And so in some cases, it's very important to think about the indemnity provisions of these tools. And just like with the confidentiality provisions I mentioned earlier, some of the free versions of the tools, the terms or legal terms are not very favorable. So for example, the user indemnifies the tool provider if the output infringes. With the enterprise versions, typically the tool provider will provide an indemnity to the user. It's important to understand, though, that even the tools that provide indemnities, some of them have preconditions. So for example, with Microsoft Copilot, they do provide indemnity if the output infringes, but the preconditions are they have a set of what they call guardrails that you have to implement, which minimize the likelihood of infringement. So there's certain things you have to do with the inputs and metadata, and there's a link on their site that you can see of what's there. But the point is, and it varies by tool, but it's important to understand that even if there's indemnity, it may not automatically apply. And with Microsoft, they make it very clear that if you seek indemnity, the first thing they're going to ask you is to establish, and the burden's on you, according to them, to establish that you met the preconditions. And if you haven't met the preconditions, they're going to deny the claim. Okay. This is just a little bit more on that. I won't go into this in great detail. I covered it at a high level, but this just is a kind of a takeaway for you as you kind of review the deck later on. You see the guardrails and mitigations that we can talk about here. Okay. Chatbots. Chatbots are a very popular tool. They cover a wide range of types of things. Some of it can just be text in and text out, where you're asking questions and it provides answers. In some cases, you may provide a text input and ask for something else to come out, like images, whatever. There can be various forms of chatbots, but what's important to understand is that, as I mentioned, like with Utah, and we're seeing in some other pending legislation, there's going to be a requirement typically to disclose that that a person is interacting with the chatbot and not with a human. There's a whole set of issues that can arise with respect to recording of chatbot conversations. And it could get into some of the wiretapping laws. So it could be civil and criminal penalties if you violate these. This varies by state. When it comes to recording of conversations, some states are a single party consent, some are dual party, meaning one party, if one party consents to recording, it's sufficient. And so if you're a party to a conversation, you can consent to it. Some states, both parties have to consent. So it's important to look at this on a state-by-state basis and make sure you understand which laws here apply if you're recording. Now, there's another thing before I move on that's important to understand, is that there's a lot of third-party tools that companies are using to do recording for them. And one of the things that's important to understand is that the tool is not a party to the conversation. It's the individuals, like if it's company A and company B, or company A and a consumer. If the recording is going to and being used by the third party tool provider, in addition to you as the company that's using the tool, that may be illegal as well and create other issues. So this is it's an evolving area, and I think it's one to watch, because chatbots are being used by many consumer brands to work with, kind of help customers, and there's a value to them, but there's these tricky issues you need to navigate. On the AI code generators I mentioned earlier, so the way these work is typically these AI models that are designed for AI code generators, they're trained on open source repositories. And for those of you familiar with open source, typically if a developer wants to use an open source component, they know what component they want. They do research on what the functionality is. They decide they want to use this component. So they know they're using an open source component. And most companies have an open source policy that says, you have to, review the license that covers the open source and make sure there's no provisions that violate the company's open source policies. Okay, so that's all fine. The problem with AI code generators is that the developers typically do not know if the output that they're getting from one of these is based on open source or if it was generated by the tool itself. And so this creates a complexity in managing open source if what is output to a developer and used is covered by or based on open source. So one of the things that's really important is for companies to update their open source policies to provide guidance to take into account these open source tools. And again, these tools work in different ways. Many companies will approve certain tools depending on their terms and their operation, et cetera. So I'm not going to say, here's what you have to do or not do, but it depends on the tools that you approve. But what companies have to do is address this and update it, because all developers are starting to use these tools. Many are using it very prolifically. You can see on the right kind of some of the level of efficiency that developers are getting with this. So it's beneficial to let them use it, but you have to manage the legal risk by updating the policy. The couple of articles there on the slide that I've prepared on this that go into more detail. Okay, so I mentioned earlier high-risk decisions. Some of the areas where we've seen activity already is in connection with AI used in connection with employment decisions. So the EEOC issued guidance, which is provided here as a link to the document. And in September of last year was their first AI-based enforcement. And there was a company that was using a third-party tool. The company was iTutor Group. They were using a third-party tool to screen applicants, potential employee applicants. And it turns out that the tool was biased in that it rejected applicants that were over a certain age. And this came to light, and the EEOC did enforcement against the company. And, part of what the company tried to argue was that, hey, we're just using a third party tool. We didn't build it. The EEOC and other agencies have made clear that liability for harm that results from these tools rests with the developer and the deployer in many cases. So if you're using the tool and there's a problem, you have a legal problem. And so this is one of the reasons why it's important for companies to both do vendor diligence, as I mentioned earlier, to understand how these tools work, how they were trained, and I'll go into vendor diligence a little bit more detail later. But you need to do this type of diligence to avoid unnecessary liability, or if there's tools that don't meet the criteria that you establish for the AI component of vendor diligence, you should just not approve the tools. That's kind of how companies are doing it now. And for the tools that are running into this problem where companies aren't using it, they either adapt or they perish, right? If companies are doing diligence and their same issues are coming up, they need to go back to the drawing board and redo their tools if they want people to adopt them. Now, some people will use the tools without doing the diligence, but over time, the information gets out that these tools have certain problems. So that is, a really important reason to do the vendor diligence. Okay. There's a number of laws that have been passed. In fact, New York City was actually one of the first to pass a law that has certain notice requirements that if you're an employer and you're using an AI tool to screen applicants or in connection with employment decisions, you need to provide notice. You need to give them an opportunity to opt out. And there's a requirement before you use the tools that you have to have an audit done to ensure the tool doesn't have any bias. There's third parties that will do audits if you don't have the internal capability to do it. But that's one of the requirements under New York City law, is that you do that before you deploy one of these tools. So again, that's part of the vendor diligence is doing an audit like that. But that's legally mandated if you're operating in New York City. New York State has law. We're seeing more and more states proposing and or passing, will likely soon be passing laws relating to AI-based employment decisions. And in many cases, the employment decision is not just the hiring decision, and not just hiring somebody, but if AI is used in decisions for promotions, bonuses, raises, firing decisions, employment decisions cover pretty much can cover the whole life cycle of decisions, not just the hiring piece. Okay. Key litigations. So there's a lot of litigations going on. There's over 30 that are generative AI specific. I'm not going to go through them case by case. What I've done is extracted out some of the kind of the key issues that are pending in across these cases. And in many cases, the legal issues are similar. There's groups of cases. And most of these cases, none of them have gone to trial yet. There was one that was supposed to go to trial a couple of weeks ago, and on the day before trial, the court put the trial off. So these cases are all pending. In many of the cases, most if not all the cases that have been pending for a while, we've gone through the motion to dismiss stage. And I'll be honest, there's a number of cases that had like 5, 6, 7, 8 claims in them. And in many cases, some of the what I call the ancillary claims weren't pled sufficiently, and the court granted motions to dismiss. So a lot of these cases have been trimmed and to focus on really the core issues, and the core issues are some of what's listed here. So one of the biggest issues is it copyright infringement to train an AI model on copyrighted material? Does that constitute copyright infringement? Is that an illegal copy that's used to do that? And what is the kind of the criteria for whether there's infringing output? And so what we've seen is authors, artists, musicians, and other creatives that their content has been used to train AI models are filing these lawsuits saying that these companies shouldn't be able to use their content to train AI models. In many cases, they're using it for free, and then they're basically competing with these creators, right? Because even if they're not copying what the content is, if someone wants, a book or an image, instead of going to a digital artist, they're for an image, for example, they can go to AI generator. So they're taking digital images that people have created, humans have created, training the models and making the human artists somewhat irrelevant. So that's kind of the theme of those cases. Um, there are a couple of cases that are relevant to this. And so some of the defense to these cases is that either there's no evidence of infringement, that there's arguments that the outputs could infringe if they're trained on the AI content. There are some cases where there actually is evidence. The complaint identifies outputs that are substantially the same as the content that it was trained on. But in some cases, there wasn't sufficient detail, and some of those cases have actually been bounced on motions to dismiss. One of the defenses that many of the companies are using is a fair use defense, alleging that training an AI model is transformative. It doesn't make a copy of the actual work that it's trained on. There's all of these tools work differently, and there's different ways to train content. It's possible to kind of compress images as part of training and retain the images. That's more likely to constitute infringement. But many of these tools train these models by adjusting what's called the model weight and not keeping a copy of the actual images, for example. So in those cases, the tool companies are arguing, hey, this is transformative, which is one of the prongs of the fair use test. And they rely on, there's a case where the Google was referred to as a Google Books case, where Google working with a lot of the libraries around the world, made copies of the world's books, scanned them, digitized them, and created a searchable index of books. But they didn't make copies of books. They didn't retain copies of the books, and it was just a tool to search. In that case, the court found that was fair use because it was largely because it was transformative. And the court found in that case that one of the other fair use factors is, what's the impact on the copyrighted work based on the result of using it. And in this case, the court found that, in the Google Books case, found that because these searchable indexes made it easier for people to find books, particularly obscure books, it actually helped the market, not hurt the market. And Google wasn't selling the book. So that's part of why there was a fair use defense that was successful there. There's some analogies with respect to training AI, but there are also some differences. And so we'll see what's going to happen with those cases. But those are, I think, some of the biggest cases. We're also seeing that a number of companies now are licensing content. So we've done some deals with some big media companies that have licensed their content with certain limitations and parameters to some of the AI companies. And so they're instead of preventing it, they're controlling it and benefiting from it. And it's kind of more of a win-win. And we're seeing more and more of these types of deals happening. One of the other claims that gets made in a number of these cases is a claim under the Digital Millennium Copyright Act for removal of copyright management information. So under the DMCA, in most cases, it's improper to remove copyright information from a work if you make a copy. When these tools train the AI, when they train their AI models based on copyrighted content, they're typically not retaining copyright notices. And this is an issue that's pending in a number of these cases. Some courts on preliminary motion have found that if the output is not identical to the material that was used to train the AI, there's no obligation to maintain copyrighted information. That test is called identicality. Is the output identical to the work that was allegedly copied to do the training? But there's a split of authorities on that. That's not an immutable rule. So that's an issue that will likely go up on appeal as to whether there's a requirement to maintain copyright if it's substantially similar or otherwise derived from a copyrighted work. I touched on earlier patents and copyrights. There's a couple of cases that have been some decided already where AI was listed as an author on copyrighted work, or an inventor on a patent application, and there's been cases, some of these have been decided that that's doesn't work. You have to have a human author. AI cannot be listed as the author. The owner of a tool cannot be listed as an author if the tool was not human generated, if the work was not human generated. So that seems to be, at least for now, unless there's a change in the law, that seems to be pretty much a resolved issue. One of the other really big issues relates to data. So I've mentioned this earlier. Data is critical for AI tools, for training. You need a lot of data. And so there's issues with respect to how data is being collected and how it's being used. There's a lot of AI tools that are basically scouring the web and just pulling everything off the web and using it to train AI. That approach may include copyrighted works. It may include privacy, kind of privacy-based information that may be being used illegally. It may include children's information that may violate COPPA. It's very fact specific, but there's a number of cases pending with respect to how data is being collected and used. And there's a subset of those that specifically focus on privacy-related information, biometric information privacy, particularly with one of the things that AI is very good at is like facial recognition, but you have to typically train it on actual faces, and facial features is one of the things protected under BIPA in some of the states. We've seen there's a case pending, as I mentioned earlier, or alluded to at least, some of these tools, because they're creating content, if what they're providing is, let's say, an answer to a question or some information that's intended to be factual, there's been a number of instances where the outputs just aren't factually correct. And in fact, they're completely made up. There's a lawsuit. There was a radio show host who, according to one of these AI tools, it outputs something saying that this radio show host had embezzled money from this nonprofit organization, was being sued over it. He wasn't involved with the nonprofit, and there was no lawsuit pending. And so he filed a defamation suit, and that case is filed. That has survived a motion to dismiss. There is one lawsuit pending involving an open source code generator that looks at issues including the DMCA, removal of copyright information, that I talked about, and whether the output of AI code generators, if it includes code that's subject to a license, an open source license, and there's conditions in that license that need to be met to use that open source code, whether you have to meet those conditions. And that's kind of the primary issue left in that case. And so we'll see how the law kind of evolves around that. So one of the things I just want to mention is that in almost all of these cases, the lawsuit is against the tool providers. The users have not typically been sued yet. It's going to happen. As soon as there is a finding, in my opinion, as soon as there's a finding that there's infringement against by using these tools, or that the tools itself create something, the users will start getting sued. So if you're using tools, if you're a company using these tools, you want to adopt the risk mitigation techniques, some of which I talked about earlier and some I'll talk about later. Ensure you have the indemnity from the tool providers, and do some of the other things that you can to mitigate risk, because I think there's a false sense of security that all these lawsuits are currently against the tool providers, but that will change. Okay, some of the regulatory guidance. The FTC has been very active for several years, actually, in regulating AI. They've issued a lot of warnings, guidance, policy statements, and engaged in enforcement actions. A lot, you can see the issues here. They're focused on all the privacy, the accuracy of the tools, the non-discrimination. They're focused on transparency and explainability. They want the tool providers to be able to explain, if there's an output, how was that output reached? And that's kind of a challenge for some of these tools. They want to ensure there's safety and reliability. And they also, they're very focused on advertising. They want to make sure that companies aren't overstating what their AI tools can do in a way that would mislead consumers. We'll see on the SEC side, companies have kind of touted their AI tools and what kind of revenue it's going to generate, and that's created some securities issues. So if you're talking about your AI, make sure that you can substantiate the claims. I'm just going to briefly mention there's an FTC investigation against OpenAI, which is one of the big developers, as you're probably aware. Um, I haven't seen much since this initially came out, but the FTC sent a 20-page civil investigative demand letter to OpenAI. If you want to see a listing of some of the topics that the FTC is interested in, and what if you ever are unfortunate enough to be on the receiving end of one of these CIDs, um, take a look at this letter and look at the categories of things, and you'll see it's where do you get your data? How do you train? How do you test? How do you make sure it's accurate? How do you ensure there's no inaccuracy or biases? And part of what they asked for is, what are your policies with respect to all of these activities? And again, and this is another reason why we'll get to in a second, why policies are important, but or what the policies cover. But this is one of the reasons it's important, is that the regulators, they're going to want to see if there's an issue, that they're going to see that you have policies that are reasonable and that you've implemented them. That will help you. If you do not have them, it will hurt you. Okay. This is just a little bit more. There's some links here to some of the FTC stuff about the advertising. I won't cover that any more detail here. And the bottom bullet there, the FTC has issued guidance, again, consistent with what I said earlier. They're focused on discrimination in credit, employment, housing, healthcare. So anything that affects consumers, patients, students, individuals, where there's potential harm based on AI tools being used to make decisions, those are going to get more scrutiny. The use of biometric information is something the FTC is very focused on. I'll talk about a case in a second, in an enforcement action that involved facial recognition. But it's important to understand that biometric information can include not just facial recognition, but fingerprints, iris scans, voice prints. Companies are using AI chatbots in some cases, for example, to, let's say, recognize a customer who's made an order at let's say a kiosk or a drive-through, is stored that voice print. And so they may not know who the customer is, but if someone comes back and there's a matching voice print, they'll know, hey, this is a customer. We know what they ordered before. And I think in most cases, the intent of this is good. It's to provide better customer service. But if you're using a voice print without authorization from the user, it may be a legal problem. So these are some of the things to kind of think about. The FTC charged Amazon with violating COPPA when it allegedly retained children's voice recordings from Alexa after parents had asked to have the accounts deleted. Obviously, that was pretty straightforward. The FTC is not alone in these actions. The DOJ is kind of ramping up their focus, very focused on scrutinizing competition in the AI space. You may have seen it's investigating a lot of the big companies that are partnering with each other. Some of the big companies are investors in the other big companies, and there's concern over, kind of the monopolization that may result from all that. Won't go into that in much greater detail, but there's some more information here if you're interested in that. Okay, so on the data side, this is something really important to focus on, right? So as I mentioned earlier, there's at least two issues. One is, how do you acquire data? And the second is, even if you have data that you've properly acquired, do you have a right to use it to train AI? And the answers to those questions are not always the same. So the reason it's important is that, for example, as I mentioned, training on copyrighted content can infringe, depends on the number of facts. Is it fair use? I talked about the Google book case. So that's one thing if it's copyrighted content. But if it's other information, like consumer information that you've collected over the years by running your business, and you have all this consumer data based on consumer transactions or consumer preferences or other things that you may have properly collected under a privacy policy that was in existence at the time. But if the privacy policy, so the acquisition may have been proper, but if you're now saying, hey, we have all this valuable data and we can use it to train AI, the question is, do you have a right to do that? And according to the FTC, if your privacy policy in effect at the time the data was collected didn't give you the right to train AI, you probably cannot use it to train AI. They've made statements. Some companies have a broad statement in their privacy policy saying, we can use this to improve our tools and services. And some companies have tried to argue, well, that's, we're creating new AI tools. These are better tools. and the FTC says, no, it's not specific enough. So this is an area that is important. If you're using customer data, it's important to train AI. You need to make sure that you have the right to do it. There's an article there that I linked to that's mentioned. And so what, of course, a lot of lawyers are doing, rightfully so, is saying, hey, we don't have this. Let's change it. And the FTC has said, merely changing your terms of service or privacy policy to permit use of previously collected data, it may not work. It may work going forward if there's proper disclosure and consent from consumers, but they've issued guidance on trying to make it retroactively apply. So if you're thinking about doing that, you may want to check out that other article that's there. Okay, so here's an example of a real case that where data misuse was an issue and algorithmic disgorgement was the result. So there's a company called Everalbum, and they had an online photo sharing service where users uploaded pictures, and they, the technology enabled them to create albums, share albums, maybe edit the pictures, to do all the things you typically do with photo albums. So Everalbum had all these images that it collected over the years, and again, all properly collected because they were uploaded by users, for purposes of the photo albums. At some point, Everalbum decided, hey, we can use this to train a facial recognition tool, and then start marketing this facial recognition tool. They didn't have permission to do it. The FTC enforced, and the result of it was was algorithmic disgorgement, which I mentioned earlier, and they had to delete the models that they built with the AI. They had to delete the algorithms that were based on it, and any of the data. In some cases, they retained data that customers, when they close an account, they sometimes kept the user's picture. So any improperly obtained data had to be deleted as well. So short of it was they lost a lot of money by going down this path, spending all this money doing it, and then having to delete everything they built. So they're not alone. The FTC is going to have to write aid. There's other companies that have had similar issues with algorithmic disgorgement. I mentioned the SEC. Yeah, I mean, if you're overstating any technology, whether it's AI or something else, the SEC, for purpose of trying to drive your stock price up, the SEC is going to take, kind of concern about that, and they've done that specifically in connection with some AI. I'm not going to go into this in great detail, but just to give you a sense, the FTC has been very active, so that's why I focused on them the most. But the FCC has been involved in regulating using AI-generated voices and robocalls, and precluding that. The DOT has been involved in AI in connection with self-driving cars and other AI-related stuff in connection with transportation. The FDA has a whole set of guidance and is continuing to provide more in connection with the use of AI in medical devices or medical-enabled devices. So the point here is, depending on this kind of goes back to the nature of the tools, depending what you're doing, there can be a whole set of regulations that apply based on different agencies. I talked a little about the EEOC already. There's just some additional information here, so I won't go into that in great detail. Same with the New York City law, but there's some additional links there that might be helpful for you. Okay, so let's kind of zoom out a little bit to current policy, right? So last October, the White House issued an executive order, basically has 7 pillars, and you can see here that these are the areas that the White House wants the agencies to focus on in connection with AI. As part of this, many agencies now, well over a dozen, if not more, have appointed chief AI officers. The effect of the White House executive order is going to be far-reaching. It's really going to impact many of the agencies. They're already issuing guidance, taking steps to do enforcement where they need to. And some of this is focused on companies and the kind of the business side of this. And part of this is designed to promote the use of AI by the government and the government agencies in connection with operating their agencies. And there's a whole set of issues around how they're going to do that in a responsible way. So I'm just going to kind of leave this as a high level. If you really want to get into the policy side, there's a lot of information here you can kind of dig into. One of the things I find very useful is Stanford's human-centered artificial intelligence group basically extracted out all of the mandates from the White House executive order, and there's 150 of them. And you can see here the distribution based on the policy issues and then which federal entities are mandated to take different actions. So there's a live link there. You can kind of see updated information. There's been requirements at the 90, 120, 180 day marks or 270 day mark to for agencies to take certain actions. Every deadline to date has been met, which is pretty rare for these types of situations. The 1 year mark is the end of October, so we'll get the final actions that are due under the initial White House executive order should come out by the end of October. So there's a lot of things pending as a result of this. Okay. When I talked about responsible AI, one of the ways to assist in managing whether what you're doing is responsible AI is to really consult the NIST, which is the National Institute of Standards and Technology, their AI risk management framework. They issued guidance back in 2023 as a result of the White House executive order. They have actually updated that with 4 new documents. NIST is a voluntary framework, so it's not a law. You don't have to comply with it, but it's deemed by many people to be at this point like the best practices. The Colorado law that I mentioned earlier references that certain things that developers and deployers must do, that they must meet the minimums for nationally recognized standards. They didn't mention this by name, but that's an example of how it actually this may have the force of law if a statute deems it to be kind of a standard that's required by the law. These are some of the updates that they've provided. I'm going to skip through those so I can get to some of the other issues here. They also created the U.S. Safety Institute, AI Safety Institute, some information there about that. They're just really starting to get going, but they're holding hearings, getting input, and developing additional guidance on how to use AI responsibly and safely. On the proposed legislation side, many of the issues we talked about, copyright, privacy, deepfakes, transparency, all of these things are pending laws. Who knows which, if any of these will pass at the federal level. There's been state laws. I mentioned Colorado is probably the most significant one that's passed. It has passed and been enacted. It comes into force February 2026. There's some additional information here about what that covers. California, I think it was just this week, Gavin Newsom signed 5 bills into law that are California AI bills that cover the topics that are pending here. These are the 5, I'm sorry, that were signed this week. Okay, so on managing legal risks, these are some of the key takeaways. In my opinion, every company needs to have an AI policy. You need to have role-based AI governance. As I mentioned earlier, depending on how the company is using or what role they're playing with AI, the policy will need to dictate different things. If you are training AI versus just using it, policies are going to cover different things. Okay, how do you do this? First and foremost, it's important to form an AI governance committee. You need to have representative individuals from different parts of the company. And depending on the nature of the company, it's going to be people from legal, it might be marketing, it might be finance, executives. You need to decide what is all the input you need, the right input in decision makers to develop a policy that's going to work company-wide. CTOs for open source code generators and other technology and vendor deals, et cetera. So that's the first thing. The second thing is they need education. And this is not intended to be offensive. They need legal education. A lot of these people, even some of the lawyers, don't know the issues, but the people who are non-lawyers most likely don't know the issues. You can't formulate a good legal policy if you don't understand the legal issues and the business ramifications. A big part of what I'm doing is going in and training companies, helping form these committees, training companies. And then once they're trained and they understand the issues, then they can actually get down to building policies and deciding what risks are acceptable, what uses are acceptable for the company, and all the other factors that go into these policies that we'll touch on. So that's a big part of what I think every company needs to address, because if you have employees that are using AI and you don't know what tools they're using, you're probably going to have liabilities that you won't know about until down the road. And so you really need to kind of do this now, because everyone's using these technologies, right? Whether it's ChatGPT or more sophisticated tools. You need to adopt policies for enhanced vendor diligence for AI specific products. And you also need to think about your third parties. If you have third party contracts where people are developing content for you, whether it's code or images or marketing materials or whatever it might be, you need to develop a policy for managing them and deciding what they can and can't do with respect to using AI in connection with services they're providing to you and deliverables they're creating for you. There's some more detail in this link as far as, kind of the type of training and what some of the policies need to include. But just to cover some of them, as I mentioned earlier, a lot of times I get a question from my partners, hey, can you send me over an AI policy for this company? I'm like, the answer is no. I don't know what they're doing, right? So you have to customize them. It really is not a one size fits all, and they vary significantly. Okay, so we talked about the steps, the governance, the training, the policies. It's really important if you're training AI that you really kind of dig in on the NIST policies and other best practices. What we typically do, the way I typically approach it is we develop these checklists to do AI policies. And while we've got a kind of a core checklist, depending on the nature of the company, some of the topics may vary, but we started out with, not surprisingly, what's the company's role with AI? What are they doing? What are the types of activities that they're engaged with? Then we talk about the types of content they're generating and how it's being used. We talk about the types of tools that they use or want to use and for what purposes. Then we use, we'll figure out, are the developers using AI code generators? Where is this company operating geographically? Because there's state laws, federal laws, and international laws that may apply. And so, this is not a complete checklist, but these are some of the things just to kind of get an overview of what the company is doing. And then to assess, like, okay, so what are some of the legal risks? And then once you identify the risks, you can develop policies to mitigate those risks. As I mentioned before, if you're training AI, data is really important. We typically do a data mapping. We try to understand what is all the data that we use to train the AI, where did the data come from, what were the terms under which the data was collected or otherwise acquired, and is there any risk with how the company wants to do it? Ideally, the company will do this before they'll go through this and develop this policy before they spend a lot of money training. So you don't have to say, hey, you can't really undo training. Once the training is done, in many cases, at least some cases, you can't undo it. You have to go back and just retrain the models from scratch. So this is kind of some of the steps if your companies are training AI, and the earlier you do it in the process, the better it is. On the vendor diligence, so I've talked about this a couple of times at a high level. It's important first to understand there's two things that are going on. One is there's companies that are building and selling AI tools where the tool itself performs some AI or some set of AI functions. But there's also many tools that you're already using where the vendor is adding AI features to your tool. So like Microsoft Word, for example, they're adding Copilot. So all of the issues I talked about can apply whether it's as kind of a standalone AI tool or AI integrated into an existing tool. So this is an example of where you need to manage and understand that if the vendor is adding an AI feature or wants to add an AI feature to your tool, that you do the diligence before you agree to it. You have to understand what are the legal terms, what are the ramifications, how's the tool working, what are the risks, the things that we talked about earlier. Okay. And I'm sorry, one other thing is you need to do diligence on what their development policies are, right? So from the standpoint I mentioned earlier about, it's important that you can be liable for what a tool does as a deployer. Because of that, you want to understand from the beginning, where did the vendor get the data from? Did they have a right to use it? How did they train? What are the steps to ensure that they do responsible AI development, et cetera? You want to go through that entire process to get comfortable that the tool or the feature that's adding AI is something that doesn't present unnecessary legal risk for you. These are just more of the kind of the topics. We touched on a lot of these earlier. I think it's helpful to ask a vendor if they have a written AI development policy. If they don't have one, that's probably a red flag. You want to figure out, does the vendor, kind of they follow NIST practices or not, et cetera. So you can see here's kind of a list of some of the topics. Again, it may vary depending on the nature of the tool. It's also important when you're doing diligence in connection with deals, whether it's M&A or finance, kind of go through some of the issues. A lot of the standard diligence questions that people ask in any deal are, of course, are going to be relevant, but there's some AI specific issues in light of some of the topics that we talked about. And there's a link to an article there at the bottom that goes into some of the additional topics and why there's unique legal issues with generative AI, many of which I covered today, and how do you deal with that from a diligence perspective and reps and warranties in the deal docs. There's I'm a member of a group called iTech Law. We've developed a couple of diligence questionnaires or checklists. One is AI specific, and then there's another one that's kind of more general for M&A. So if you're a member of iTech, if not, you can I think you can get a copy of it. Those are all public. So with that, I know we covered a lot. I went through some of it kind of quickly, but there's a lot there. Feel free to reach out to me. Connect on LinkedIn. We have a blog at AI Law and Policy that we cover a lot of these issues and provide a lot of useful information, some of the checklists that I mentioned, et cetera. So hopefully you all found this to be helpful, and I'd be happy to answer any questions.
Awesome. Thank you so much, James, for that wonderful presentation. We can now go ahead and move on to our audience questions. So if you have any questions for James, please feel free to submit them through that Q&A button in the control panel at the bottom of your screen. Looks like we've already got a few. James, do you want to go ahead and select which ones you'd like to answer?
Sure. So the first one I saw pop up, it says, of the current litigation involving AI, are there any general takeaways or lessons for lawyers managing legal risks? Yeah, I mean, I think a lot of it is what I covered today. If you're training AI, make sure you have a right to use the data, that you're not, using copyright protected information in a way that would constitute infringement. The open source code generators, that case that's pending, is understand, when using it, if the output includes open source, you're going to have to manage that just like you manage other open source, but there's some other issues that go along with that. The definition, if you're, again, if you're developing or using tools, you have to check the outputs, right? So, if you're building a tool, you want to design it in a way that you do the best you can to make sure the outputs are accurate. But if you're using a tool, you cannot just rely on the output of one of these tools and assume it's accurate. So, you got to fact check it. So again, these are some of the things that people get baked into the policies is if you understand what these issues are in litigation, those are some of the things you definitely want to take into account in your policies to avoid situations where you just overlooked it and may have liability as a result. The indemnity is a really important issue as well. So, all the things we talked about would be kind of the key takeaways. Next question. What provision or issue raised via executive orders or legislation on AI would you say is of most immediate concern for lawyers advising clients? Again, I'll try to answer this directly as possible. It really depends on what the client's doing and what their role is with AI, not to sound like a broken record. But what I would say is disclosure is a big thing. If you're using chatbots, if you're dealing with consumers, the disclosure and transparency is important. Second, the data issues, privacy, biometric privacy are focused there. As I mentioned, anything consumer related, anything impacting individuals. So whether it's consumers, patients, students, employees, any tools that are being used that could have an adverse impact on individuals, those are being highlighted in getting special protections. So those are, I'd say, some of the key areas. Next one, what specific steps should companies take to create an effective AI governance committee, and what roles should be represented on this committee? Again, it really depends on the company, but I really think that in the beginning, more representatives the better. I'll just go through kind of quickly. Obviously you want to have legal folks involved because there's legal issues. You want to have technical folks involved to be able to vet the tools from a technology perspective. Executives, I mean, if you're going to allocate money for training AI because there's a huge investment, you want to understand, make sure there's policies. You typically want to have executives involved to understand what the risks may be or how to ensure that the risks are mitigated. Marketing, to the extent that companies are going to use AI, and a lot of them do in connection with marketing, you want to make sure that they're involved and understand how they're going to use it so you can make sure the appropriate safeguards are put in place. those are, I'd say, some of the key areas to think about. It can be, it can vary again depending what the company is doing. It certainly can involve many other companies. We see AI committees anywhere from 5 to 25 people right now. I mean, it just really varies significantly. Um, what are some of the key challenges companies face when implementing AI governance structures, and how can legal counsel help navigate these challenges? Great question. I think probably the number one thing that I think is an issue is just a lack of understanding of the issues, which is why I think training is really important. There's a lot of people that are very smart technically or business savvy. Everyone has their skills. But I think really in order to have effective AI governance, you need to understand like how the tool is going to be used from a business perspective and the technology part of it. But you really need to have people understand the legal issues and the ramifications of what can go wrong, so that when you develop policies, there's an understanding of why these policies are here. There's a reason for them and they make sense, and we understand the risks we're mitigating. So there's both a training that we do of members of the governance committee, and many times there's a plan for rolling out employee training as well, so they understand the policy, the reasons, and the issues and the ramifications of not following it. Okay, next question. How do the current AI policies and legislation address ethical concerns, particularly around issues like bias, discrimination, and privacy? Um, so all of those go into the topic I referred to as responsible AI. The White House executive order, I actually wrote a separate piece. If it's not linked in the materials I provided, feel free to email me. I'll send it to you. But I went through the White House executive order and pulled out all the different aspects that related to these topics, because there's a number of mandates in the White House executive order to different agencies, but all of those that are in that one article focus on the issues you ask in your question. And there was also, as I mentioned, there was the White House executive order mandated the creation of the AI Safety Institute, which is now set up, which I had a slide on that. And it also mandated that NIST update their AI guidance, which they have now done. There's 4 new documents that they've provided. So I would say it's pretty comprehensive in that there's a significant focus on it. And it's not just policy talk. And I think, kudos to the agencies for doing what they're doing, but they're producing useful documents that can help companies and lawyers navigate these issues. And it's not the job's not done. These tools continue to evolve. So this stuff will continue to evolve, but there's tangible results from the executive order on these topics already. How can companies develop role-based AI policies that ensure employees at all levels are compliant with AI regulations and ethical standards? I laugh at this because I deal with this with clients all the time. You can develop the best policy in the world, if your employees don't follow the policies, it's not going to help very much. So, like any other policies that you have, whether HR policies or any other policy, it's going to vary a bit by company. But you need to develop the policies. In my opinion, it's really good to have good training of employees, to help them understand what the policies are, and why they need to comply. And then you need to have some, enforcement mechanism. You need to have a way of checking if employees are complying, and some ramifications if they don't. I don't really know any other way to really do it other than that. But how you do that kind of varies by company. In some cases, like take like the AI code generators, like typically there's going to be, whether it's the CTO or someone, or it could be project leads that are responsible for ensuring that all the updated AI code generator policies are being met with respect to a particular product, or in some cases across the products. So I think, designating individuals for different parts of this is part of, the rule, but there needs to be something company wide. I think these need to be mandated from the top down. These are not something, in many cases, are just coming from the legal department. This is company wide policy, and is typically mandated from the top down. The next one is just a kind comment. Thank you very much. And then, how can companies balance innovation in AI with the need to comply with regulatory and ethical requirements without stifling technological development? That is the multi-million-dollar question. Look, I think that the issues that I touched on, kind of frame out a lot of the issues that are there, and the additional materials they provided. I think depending on what the kind of the nature of the tool is you want to develop, it's really important just to understand where are the minefields, right? If you're developing an HR tool, you got to understand what's the legislation, both existing and what's pending, so you can kind of build on what's coming, or how is use of AI in employment decisions being regulated and going to be regulated, right? So part of it is just understanding the issues, and it's evolving, and that's why part of what we're doing a lot of these companies is there's ongoing training and updating so that they can be stay abreast of the issues and make changes as necessary. It's I know it's kind of a high level answer, but it starts with understanding the issues, and then figuring out the best way to implement them based on the tools that you want to develop.
Awesome. Thank you so much, James, for that additional insight. And thank you all so much for submitting your questions. We want to thank you all for joining us for another Justia webinar. I also wanted to remind you all, as I did at the top of the presentation, the website services that are available to you through Justia, Justia Elevate. Justia Elevate is our groundbreaking WordPress-based platform that's designed to take your law firm website to new heights. It has many different features, but the one I want to highlight today, in keeping with our AI-focused webinar today, is our Justia AI Content Writer. Our Justia AI Content Writer is designed to help you develop easy legal content on a plethora of practice areas and legal topics to help boost your website SEO. If you'd like to learn more, you can go to elevate.justia.com. Have a wonderful rest of your day, and thank you again, James. Have a good one. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.